Thank you so much. We are in our final panel, so thank you for staying with us until the very end. As the last panel already teed up for us, this panel is going to address the question, where do we go from here? And as the last panel already referenced, some discussion about AI that certainly is a pressing issue that we will discuss, as well as others. We do have, I just want to mention the Zoom speaker, Keith Robinson, unfortunately was delayed by the weather back east. So Keith is from Wake Forest University School of Law and will be presenting via Zoom. So welcome, Keith. But the order of the speakers will be the same as the schedule, and I will repeat something that Tyler had said at the start. The full biographies you can find on the conference website. In the interest of time, we will be relatively brief with biographies. With that, I will turn to our first presenter, BJ Ard, a professor from the University of Wisconsin Law School.
All right. It's a privilege to be here. I'm grateful for Ed's invitation to be a bit speculative and big picture. So 50 years after the passage of the 76 Copyright Act, we face a paradox. Copyright has grown somewhat less prominent in its traditional role of governing the market for creative works, and it's also being pressed into service for new purposes beyond those it was designed to handle. So to explain, let me probe three dynamics. First, copyright seems surprisingly peripheral relative to what we might expect in some creative markets. Copyright shares the stage with contracts, technological architecture, and business models that supplement or displace it. In some sectors, you could scale copyright dramatically up or down and see only muffled impacts. Consider consumer copying. That was a problem that dominated policy debates for decades. It's now largely solved through mechanisms beyond copyright. Piracy has declined, and subscribers to services like Spotify now vastly outnumber bootleggers. Unlicensed consumer copying fell off because of changes to business models and technical architecture. All-you-can-eat streaming meant that there was little to gain from a la carte downloads, and cloud-based services meant that people didn't have easy access to files that they could share. And really, maybe it was the last 50 years that were the anomaly. Before 1976, copyright was focused on professional activities rather than home use. The 1975 Betamax and 1977 Apple II changed that because they launched decades of conflict over home taping and later file sharing, sometimes with hints of brand copying. And so we had Sony, the Audio Home Recording Act, the DMCA, Napster, Crocster, SOPA, FIFA, and more. But we've returned to something closer to that pre-1976 equilibrium, where whoever copyright is speaking to, it's not primarily consumers or their behavior. And copyright has also become attenuated from the rules for content that secondary users are uploading to platforms like YouTube. As Zian Teng and others have explained, platform policies and right holder deals are both more and less forgiving than copyright. Content ID systems are criticized for running roughshod over fair use, but at the same time, these platforms are allowing secondary creators to make many uses that otherwise would not be fair. And Jeannie alluded earlier to these systems where the licensing deal is one that leaves users and the public out of the process, and often in the dark. Even conventional big-budget productions stand in a complex relation to copyright. I had examined this phenomenon in my study of video games, where I argue that copyright shapes the market of content for games, largely because it's unreliable or unavailable for combating game clones. Rather than relying on copyright to deter second comers, we see investment in these hundreds of millions of dollar productions going into factors that are either costly to duplicate, like bleeding-edge graphics and multi-million-dollar marketing campaigns, factors that are more squarely protected by trademark or copyright because they go to the narrative or sequelization, these story elements, or permutations of the two, like the engagement of celebrity voice actors and likenesses, which are investments that are both expensive and bolstered by other rights, such as the rights to publicity. And the point is not to say that this sector is representative in its proportions, but to suggest that hybrid arrangements that are only partly governed by copyright and only partly by other legal and extra-legal constraints exist in various proportions across the board. And this dynamic of copyright's steering effect shades into the second dynamic. Copyright has taken on unexpected roles in shaping technologies and business models. Rather than directly governing engagement between content owners and follower users, it sometimes pushes market players to design around the regime. And we see these efforts sometimes from those who want to engage with copyrighted works through a more permissive regime. The dynamic motivated the escalation of peer-to-peer services from Napster to Grokster, each attempting to exploit perceived gaps in doctrine, and the subsequent migration of pirate activity outside U.S. jurisdiction. Famously, Aereo also attempted to exploit a perceived blind spot and failed. In parallel, content owners have been designing around copyright to gain greater control. The RAM copying doctrine and judicial endorsement of boilerplate from Pro CD onward have enabled licensing models that contractually overwrite many of copyright's provisions. Cloud-based streaming services have continued this trend, but often without even the need for legal enforcement because it's simply built into the system. So in addition to being just one factor among others in many creative markets, apparent dissatisfaction with copyright has driven many attempts to opt out of it. And I'm not putting a normative gloss on this today. On one view, all copyright should be doing is setting the initial entitlements, and subsequently then copyright would recede into the background and allow private ordering to flourish. The counterpoint, of course, would be to dig deeper into whether the flourishing of these markets is in line with copyright's objectives, and to question whether the non-transparency or the limited ability of some of these arrangements raise concerns of their own. All I aim to do is to put flesh on the question of whether the future of copyright is one where it cedes the stage, or one where Congress and the courts give it a more prominent role. And it's too soon to tell whether AI litigation is going to mark a different inflection point. Likewise for Sony versus Cox. Copyright may be AI's biggest legal stumbling block, but private ordering and refinements in the technical design are moving quickly. Copyright litigation has become central to AI discussions, partly because it's a proxy for larger policy fights around the implications of AI. Partly also because these lawsuits and the public commentary invited by the Copyright Office have presented some of the only formal venues for actually airing out or working through these issues. And this brings us to the third dynamic. Some want to instrumentalize copyright for new purposes, as a vehicle for working through labor policy, competition concerns, privacy interests, and others. There are voices that call for copyright law as the body that we would generally associate with creative production to grapple with larger upheavals that AI is precipitating with respect to existing markets and the future of creativity. And of course, this expansion of copyright deliberations beyond the production and enjoyment of creative works is not entirely new. Paul Ohm and Blake Reed had an instructive study of prior DMCA proceedings that veered into safety and environmental concerns in deliberations over vehicle repair. But the scope and the pace of these arguments seem accelerated. Without comprehensive privacy legislation, with limited antitrust enforcement, with limited political will for new AI regulation, copyright becomes a focal point. And these are all issues that I care deeply about. But there are limits to what copyright can do or could be expected to do. If you thought that generative AI was ruinous and that copyright should be called into halt it, I'm not sure that you could. You could eliminate fair use for AI training entirely, and yet the technology would still proceed. We have licensing deals moving forward either voluntarily, as in the case of Disney, or sometimes with the rights holders unaware, as with social media platforms whose terms of service allow for training on used materials. In the image space, there were select companies that already controlled stock libraries that were large enough for in-house training. Now, the AI systems coming out of any of those arrangements would still leave us with concerns about human creators being outcompeted and overwhelmed. And this goes beyond copyright's usual competitive concerns, because this displacement is an issue even for artists, even for other authors whose works were not in fact tradable. Likewise, we still see the proliferation of scams and deepfakes, and a competitive landscape that systematically favored large AI companies operating in a concentrated market. So, copyright disputes have been valuable in bringing many of these issues into public view. But if copyright does less work than expected in some of its traditional domains, why do we expect it to work in these new domains where the fit seems to be worse? In thinking about creative production, it's worthwhile to broaden our scope and recognize copyright's place alongside other legal regimes and alongside the market and technological contexts where it operates. Copyright is providing necessary infrastructure and ground rules, but it may be doing less work than both champions and critics assume. And perhaps that's okay. Copyright was never meant to do everything, and asking it to solve labor displacement or privacy or market concentration may be asking for it to fail. The work ahead is going to require us to sort out which tools to use for which problems, and not to default to the one legal hammer that we know.
Thank you, BJ. Our next speaker is Colleen Chen, who teaches at UC Berkeley, but we welcome her back to Santa Clara Law.
It's so great to be here. Thank you so much to Ed and Tyler and the other organizers. It's wonderful to be at Santa Clara. And I think some of the remarks I'm going to be making are based on my time being here, thinking about a human-centered perspective on intellectual property. Because while many of us, I think, have been approaching the patent system from a critical perspective, concerned about its excesses, low quality, and rent-seeking, there has also been another strand of discussion around equity and inclusion in the patent system and the ways in which you can boost entry in the service of innovators and not just innovation. We kind of step outside of this room, we know that we're in Silicon Valley, the richest district or county in the United States. And that even though recent trends have been more positive, U.S. life expectancies remain below many of our counterparts. Concerns about addiction and loneliness are pervasive, and the question of technology in the service of what ends is increasing. So my comments today are at the intersection of these things in light of the biggest technological change, certainly in our lifetime, of AI, and all the ways in which AI is starting to and likely will be changing the patent game. Because as Mark mentioned in his comments, the patent system can and does change in response to changes in technology, law, institutions, and Donald Trump. But in this final Blue Sky panel, I think it's worth thinking about how AI might, as it shakes up everything else, also shake up the patent system. One way in which it's likely to do so is through the removal of frictions and barriers to the system. In the realm of patent acquisition, for years patenting has been expensive, acting as a barrier to access to the system. But now LLMs are capable of producing higher and higher quality technical descriptions and claims at much lower cost, putting patents within the reach of those with prompts, not just patent lawyers. While still elusive, the holy grail of greatly improved prior art search is also more available than ever, based on semantic search and finding references that human examiners would take a lot more time to find or miss entirely. We'll see what the next generation of patent examination brings, but the rhetoric of the current administration on AI, largely go, no guardrails, suggests a world in which specifications written by patent prosecutor bots are reviewed by examiners using office action generator bots is coming sooner rather than later. Once patents issued, enforcement is also poised to become more accessible. AI agents that scour product offerings and look for infringement are not far from being a reality. Once found, AI can map patent claims to potentially infringing products with surgical precision, in theory. Even in more complex cases, AI tools now are being used to digest pages of evidence and make predictions. Now, as we're seeing platforms resolve disputes in IP on a simplistic level, you can see that those predictions in many cases are going to be good enough, potentially reducing the need for lawyers to be involved in the decision. Analyzing market trends and litigation history, AI is also making the process of figuring out the actual market value of licensing for licensing or dispute resolution a lot easier. But more importantly, the nature of inventing is changing. If patents are about stimulating innovation in a world of scarcity, AI is about creating abundance. You all have seen the headlines around advances in computation, data availability, and AI-assisted research, dramatically lowering pretty much all steps and costs of innovation. At the ideation phase, one person's hallucinations are becoming another's novel, non-obvious synthesis. To reduce one's ideas to practice, experimentation is becoming cheaper and iteration is accelerating. This is perhaps most excitingly impacting drug discovery, but also the worlds of carbon, material science, and geology. So what happens to the patent system when much of what once required ingenuity becomes obvious? As the late and great Dan Burke observed, when creativity is achieved, the role of intellectual property shifts towards certifying authenticity and interest advanced by trademark law in one iteration. In the realm of patent law, the category of non-obvious begins to shrink, not the margins, but structurally. Because as we know, obviousness doctrine is about rewarding creative combination where knowledge is fragmented and where invention requires a leap beyond what a person of ordinary skill could readily achieve. But today's tools are making those combinations cheap, fast, and increasingly routine. R.D. Wright has called for embracing reliability through patent doctrine. This is going to require not only changes to non-obviousness as well as inventorship, but also she calls for the fortification of the utility requirement. But I'd like to consider not only the doctrinal implications, but also the distributional ones. The system continues to reward the first filer who industrializes what has become broadly foreseeable. Patents risk functioning even less as incentives to invent, and more as mechanisms for appropriating returns from lower transaction costs. In one world, rights will flow disproportionately to those with scale, compute, and who know how to play the game, not necessarily to those who supply the underlying insight that this is what we need. At the same time, to integrate the college debate of Mark and Rob earlier, lower transaction costs are changing what is needed to coordinate complex innovation, a lot of which is not patent rights. But if coordination is easier, if licensing, disclosure, and collaboration can happen faster and more transparently, then we could see a renewed role of patents from exclusion to signaling, from blocking to structuring participation. This, to me, is the juncture at which the long-term evolution of the patent system becomes quite interesting, and portend a potential future shift in emphasis from an innovation and corporate-centered system to an innovator and human-centered patent system, and doing the things that the patent system is best at, where it really makes a difference, in validating startups, first-time inventors, and setting them both on a different course, as Farah Mendel et al. And others have shown, and in facilitating transactions, as Rob has demonstrated, not only in his remarks today, but in the legacy of his work on IP transactions. And ultimately, in creating new things that serve actual human needs. A human-centered patent system asks a new set of questions than the ones that we've typically been grappling with. Instead of asking whether patents stimulate innovation in the aggregate, it asks, for whom does the patent system work, at what stages of innovation, and under what conditions? Who is encouraged to take risks, and who is deterred? Who can navigate the system, and who is filtered out before their contributions are even visible? Whose needs are met, and whose are neglected? On the side of the innovator, this portends a shift to thinking about patents primarily as fixed tools of exclusion to seeing them more as flexible tools of expression, to refer to a conversation that Jeannie Farmer started more than a decade ago. This could mean paying more attention to attribution, who gets credit, because as emerging work seems to suggest, being on the patent for the first time can really matter. I think Pete's going to talk a little later about problem recognition and the importance of that, and it becoming even more important in this day and age. It also could be paying attention to things like inventor remuneration as recognized in other countries. But as Jessica Silvia's work has taught us, with all creative acts, it's also about control. What does the innovator actually want to do with their patent right? Are they looking to use the patent as a point of pride, a defensive mechanism, an invitation to collaborate, or defense? To borrow from the world of AI governance, there are a number of ways to keep a human in the loop of the patent system and to make patents more personalized. Right now, on the innovator side, the patent system doesn't give a lot of options for human expression and intentions to come through, save through things like maintenance fees indicate an abandonment of the exclusive right. But while we've seen the possibility of other types of instruments and choices for innovators, things like defensive publication, patent applications published upon filing, patent run a fast track, and potentially on a slow track, there has been much less consideration of the needs of consumers or humans. And that's where things could get a bit more interesting, which is to see the innovation system to a greater degree as incorporating and centering the perspective of the consumer. To bring it further upstream, we might see the patent system shift towards the point of human novelty, problem recognition, and problem articulation, hopefully bringing it in closer alignment with actual human welfare. One could imagine several scenarios. For example, patient groups that are able to draw attention to their needs by creating the equivalent of multi-shot prompting that defines what the desired characteristics of their solution are, to be able to rapidly prototype and develop at least a first draft of an invention. Or certain consumers to be able to use their own needs, thinking about parents who are struggling with dealing with their kids, working with social media or their own addiction, but centering their own experiences and vibes to describe the contours of the technological innovations that they'd like to see meet their own needs, even if they don't have any practical or ability to experience in such technologies. The role of the patent system would still need to be determined. Perhaps it's just groups staking out the idea and on the basis of one embodiment of the idea, getting some sort of exclusivity and then finding entities to do the development work and commercialize the technology, but with some exclusivity already in place. But other instruments like prizes, advanced market commitments, may be even more important as problem recognition takes place. So, where does that leave us? We might imagine a world in which the patent system over time is pulled into a new equilibrium, one that's less about pitting rights holders against implementers, and more about human needs and technological possibility, contribution over accumulation, and control over conflict.
Our next speaker is Camilla Hurdy from Rutgers Law School.
Actually, my back is raised. I might just stand. That's okay.
Sure.
It's not because I think I'm going to say anything exciting. My back. So this will work.
Yes.
Okay, great. So hi, I am here to talk about trade secrets. I'm supposed to talk to you about solutions. However, in order to discuss the solutions that I have, I need to tell you more about the problems. And you'll note that there was only one other person here who talked about trade secrets, so you do need to hear more. My solution, I think, will make more sense when you hear the problems that I'm going to discuss. So as Sharon explained this morning, trade secret law evolved in the common law. It was codified at the state level through adoption of the Uniform Trade Secrets Act. And then in 2016, Congress codified the Trade Secrets at the federal level. We got this Defend Trade Secrets Act, private right of action for misappropriation of trade secrets. It is largely agreed today, and I would say it's incontrovertible after the passage of the DTSA, that trade secrets are now an intellectual property right on par with patents, copyrights, and trademarks. And yet, there is a continuing lack of consensus about the meaning of fundamental statutory terms in the trade secret laws. I thought when I first learned trade secret law back with Jim Cooley at Berkeley, 2007, I thought when I first taught trade secret law for the very first time, I thought, oh, all these questions I have, I just don't know anything yet. I haven't done enough research. I haven't seen enough cases. There are answers, I just don't know them, right? And now that I've read more and talked to people who know way more than me, it turns out, guess what? There are no answers. Courts and practitioners are as uncertain as I was when I was a first-year law student. There is also tremendous jurisdictional variation on many important issues, despite the existence of a federal statute. Now, jurisdictional variation is not per se bad. It can even be really good. But in this case, it's just really confusing and sometimes overwhelming for judges or for those practicing in the field. And given that we have a federal statute, you would want some convergence, especially on core federal statutory textual issues. So here I'm just going to go through some examples of places where there is just bizarre lack of consensus and continuing uncertainty. So number one, how much information does a plaintiff need to supply when saying what their trade secret is. So unlike in patent law, which we've heard a lot about, and unlike in trademark law, where you get this requirement to identify what you're thinking of as your property, right? In patent law, you go and you apply, you write all those claims. In trademark, when you're getting a registered right, you go and you say, here's what my trademark is. But in trade secret law, we don't do that. Instead, it's identified for the first time often in litigation in a procedure called identification. Identification, it's a trade secret specific identification requirement where you literally go into court and you say, here are the trade secrets that I'm protecting. And identification law is right now in chaos. California has a statutory rule saying that the trade secret owner has to identify their trade secrets with reasonable particularity before discovery, just before discovery. So we know what the heck we're arguing about. And so that we can streamline discovery and not have it balloon into this hugely costly thing. We thought courts across the country were kind of converging into that standard, and that's what Judge Alsop thought too. And in a case called Quintara, the Ninth Circuit actually overruled Judge Alsop, said actually, no. There's a different identification standard for the DTSA. It's not reasonable particularity. It's you use a different phrase. It's sufficient particularity. So I guess it's unreasonable, sufficient particularity. I don't know. But other circuits have then have their own different conceptions. Third Circuit in Oakwood, Federal Circuit just came out with a new case, APT. So there's very little clarity on just this fundamental starting threshold issue. Second, with great interest to me, because I think identification is less interesting than what pictures do. I understand it's very, very important, but it really seems quite procedural. Moving to substance, right? What does it mean for information to be secret? You know, trade secret law has a very, very unique definition of secret. It does not mean absolute secrecy. It says information can't be generally known or readily ascertainable through proper means. So a lot of standards, not rules there, right? And you would think we would at least have gotten to some kind of convergence on what those words mean. Like, does generally known mean like, you know, if over 50% of people in the field know it, like then it's not a secret? Like, who knows, right? And what happens in the cases is that the court, sometimes there'll be like a smoking gun, a publication will come out, it's like, oh, there it is. Otherwise, they often, if the case gets that far, they just throw it to the jury. And the jury looks at everything and they say, is it generally known? And the jury has to decide. And they're really not given much guidance. Even more so, what does it mean for a trade secret to be readily ascertainable through proper means, right? The readily ascertainable limitation, readily ascertainable through proper means. This is in the DTSA, it's in the UTSA, and it's in the laws of most states. It's actually not in California. The most important trade secret jurisdiction in the U.S., or in Oregon or Illinois. So what if a secret has been embedded, for example, in a product that could be reverse engineered in 8 hours? And the defendant, instead of doing that reverse engineering for 8 hours, pays off an employee in order to get that information instead. Is that actionable under trade secret law? Apparently, yes, in California. In California, if you take a trade secret in violation of duty, you can still be liable, even if somebody could go and get that information quickly. There's a few more wrinkles there, supposed to be able to raise it as an affirmative defense, but you can't. The courts have kind of gutted that. So that's just bizarre, right? And we don't talk about that difference. Nobody seems to really care. And in Illinois, courts don't even seem to realize that the statute doesn't even say that. It doesn't even have readily ascertainable. They just have it anyway. So, and I just discovered that in my own state of New Jersey, I just moved to New Jersey, Section 5 of the New Jersey Trade Secret Act literally says you can't raise the fact that a trade secret was readily ascertainable through proper means as a defense if you yourself didn't get the information through those proper means. So it's the same as the California rule. Nobody has mentioned it. I've talked to so many people in New Jersey who have no idea about it. Jim Pooley also didn't know about it, even though he's the main person complaining about what's going on in California. Is a worker's general knowledge, skill, and experience, so sort of high-level know-how that workers automatically acquire on the job, can that be protected as a trade secret? Can it be? Like, if you've taken a trade secret class, you would think, like, no, right? Like, that's black-letter law. And yet, that isn't actually in the statute. And a lot of courts think that what we're asking, when we're asking is something general knowledge, skill, and experience. It's the same thing as asking whether somebody is generally known in the field. Meaning there is no separate exclusion for someone's general knowledge, skill, and experience at all. If something is secret to a company, that's enough, never mind if it's some kind of inevitable, a knowledge that they're going to inevitably need to work in the field. So that's bizarre. There's so much more. What is independent economic value? If you read the statutes, that's in there. Does it just mean, like, independent economic value? Not intuitive what those words would mean. A lot of courts think it just means sweat words, like, did you invest in the information? But there's there's a deeper, much deeper story there. In fact, it should mean economic advantage from secrecy. And some courts get that, some courts don't. So there's just so much going. What does improper means? If you want to talk about misappropriation, right? Is it just something that somebody does wrong? What about inevitable disclosure injunctions? A lot of us have heard about this, right? It's where a trade secret holder gets an injunction to stop an employee from working for a new company, not because the employee has taken trade secrets or used or disclosed them yet, but because they will inevitably do so. There's a huge division in the states as to whether that's okay. Apparently, the DTSA makes that remedy no longer available. And yet, a lot of courts are still applying it anyway, just totally kind of getting around that statutory language, saying, yeah, there's a threat, which is in the statute. So there's so many points of division. I could go on and on and on. Ownership, standing, contracts, right? There's so much overlooked overlap between trade secrets and contract that has raised so many issues. And just to raise a few, so obviously non-competes, right? You know that non-compete claims often come with trade secret claims. They are now not federally banned, apparently. The FTC did try to get rid of them in 2024, but that attempt has been abandoned. And yet, like, if you think very hard about it and look at what's happening, a lot of times we have strong trade secret laws, including in states like California, that are playing a really, really, really similar role to non-competes. Confidentiality agreements, can they do more than trade secrets, right? Can you have a confidentiality agreement that protects way more than trade secret law does? What about anti-reverse engineering clauses? This has been unresolved for so long. Pam Samuelson correctly noted that it just is wrong as a matter of law that breaching a no reverse engineering clause while you're reverse engineering can't be misappropriating of trade secret, because trade secret law says reverse engineering is legal. So I've talked about so many problems, and I really just have one simple solution. So possibilities are the Supreme Court, no, they haven't taken a substantive trade secret case, arguably ever really, but not really since Kiwani in 1974. Congress wasted its opportunity with DTSA, complete waste of time. They could have done so much there. Compare the drafters of the UTSA, which actually talked about the law. Practitioners don't have the time. They don't have the time, even if they wanted to step back. So what is the solution? The solution is us. The solution is academics. We need more people writing and thinking deeply about trade secret law. I'm so tired of going to conferences, IP conferences with a trade secret panel, and it's me and 3 patent lawyers, okay? So we just need more people writing and thinking about this. And people need to be talking to the practitioners, because they're out there doing this. And we don't really know anything up here. We have to go and talk to them. So my solution is we need more people thinking about solutions.
Our next speaker is Keith Robinson from Wake Forest, and I just wanted to personally thank you, Keith, for sacrificing part of your Friday evening to stay with us. The floor is yours.
Thank you. Can you hear me okay?
Yes. Yeah.
Okay, perfect. Thank you. Well, thank you, Ed, for inviting me to the conference. I regret that I'm not there in person. But thank you to Doris and Joanna as well for facilitating this and keeping me in the loop. Colleen actually teed up my comments quite well. So for about a stretch of 10 years, when I taught inventorship in my patent law class or in my IP surveying class, the discussion was rather short. Students didn't really have many questions about the concepts, and we just sort of moved on with the material. And then about 3 years, something changed. Students wanted to talk about inventorship, not only from a technical, doctrinal standpoint, but also from a philosophical standpoint. What did it mean to be an inventor? What did it mean to be a human inventor? And I think partly this is in response to the recent case law and USPTO guidance. Part of it is in response to some of the technological innovation and news we've seen about some of the developments in AI. And third, I think it's a response to our law students becoming familiar and using these tools themselves. And so I want to use my time and my remarks to explore this growing tension I see in patent law, specifically in regards to the doctrine of conception, and how it identifies an inventive contribution, and whether that doctrine is still going to map on how innovation actually occurs, especially in the era of AI-assisted invention. And so I start with a simple observation, and that is inventorship doctrine feels increasingly strained. And we see that from the joint inventorship case law. Courts themselves have called inventorship and conception one of the muddiest concepts in patent law. And a lot of scholars have echoed that sentiment, is specifically in settings where research is collaborative or technologically complex. Now, the case law tells us that conception is a mental act, and it's defined as the formation in the inventor's mind of a definite and permanent idea of the complete invention. But when you really look at how the cases are decided, they rarely turn on that specific introspection. Usually they turn on evidence and the corroboration of that evidence using documentation, timing, etc. And so the inventor's mental picture or mental idea matters only so much as it's fixed in a notebook, in emails, or other sorts of records. The case law also tells us one important thing, and that is that identifying a problem is almost never given credit as inventive. And so repeatedly, we see the courts draw a sharp line between creating a goal or a research plan and solving a particular problem at hand. And even a highly specific articulation of a problem is typically treated as insufficient for conception, unless it's paired with a concrete solution to the problem. And, there are valid reasons why the law is settled on solving a problem as conception's North Star. One is it's practical. Solutions are easy to describe, they're easy to corroborate, and they're easy to litigate. And courts are wary of rewarding some upstream cognitive work that's hard to verify as conception or an inventive activity. As a result, we see conception doctrine favoring what can be shown. Another reason is quite logical, and that aligns with the reward theory of patent law. And that is the patent system is intended to reward inventors for solving problems, not identifying problems, not working hard on problems, not almost solving problems. What the patent system wants is the solution to these problems. And it's fair to say that in exchange for a period of exclusive rights, that's what the patent system should require. So thus far, I've talked about two ends of the spectrum, right? So when it comes to conception, on one end, you have problem identification, which falls short of conception. And then on the other end, you have solving a problem, which currently is a necessary condition for conception. And so that brings me to the topic of the panel, which is, well, where do we go from here? And I think the innovation and management literature has a solution. So innovation, management, and design thinking literature suggests that there's an important step between identifying a problem and solving it. And one I think we need to pay more attention to, and this is often referred to in that literature as problem formation or problem framing. So problem identification is noticing that there's a problem, there's something off. Problem solving is fixing it. And problem formation is that hardier, muddier middle. And it's often the invisible work of constructing a representation of the problem, understanding what the constraints are, and it often determines what really counts as a solution in the first place. And this idea really aligns with a often quoted Einstein quote, which is the formulation of a problem is often more essential than its solution. So now enter AI-assisted invention, right? So in many domains, we see that AI systems can reliably generate a solution once a problem is specified. So what then happens, I would argue, is that solving problems may become a weaker signal of human inventive contribution. The hard work, the distinctively human work, lies in deciding what problem to solve, how to frame it, and determining what constraints matter. And the Innovation Scholarship has been very consistent on this point. Across design theory, management science, and creativity research, scholars continually emphasize that problem framing is as important or more important than solving the actual problem. And so we see that this creates a mismatch. Patent law, we know, insists on a human inventor, but it continues to rely on problem solving as a proxy to identify human contribution. The result is a doctrine that may undervalue problem formation. In the future, this could be the very stage of innovation where human judgment, creativity, and responsibility will be most concentrated. So at this point, it's fair to ask whether our understanding of conception will continue to be about identifying inventiveness, or whether primarily about making sure a human is listed on the patent as an inventor for administrative reasons. So I'll be the first to admit that recognizing problem formation as a type of conception introduces a host of technical problems and challenges that I haven't fully worked out myself. However, if you believe the techno and AI optimists, problem solving is going to become much easier as AI technologies advance. And I do think we have to ask the question whether an acknowledgement of problem formation is an appropriate path for recognizing human inventive activity. And so that brings me to what a recalibrated conception doctrine would need. And so again, the task is not to reward mere problem description, but to identify when problem formation reflects a contribution to solving the problem. Patent law already contains some tools like definiteness enablement that could be adapted for this purpose. So the question, I think, is no longer whether problem formation matters. Innovation theory tells us that it does, and AI capabilities are going to make this a reality that's impossible to ignore. The real question is, how should the law respond? And so I'll close with this. When AI systems can solve problems once humans define them, inventorship doctrine really does face a important choice. It can continue only valuing solving the problem because that's what we've always done, or it can begin to take seriously the idea that inventive insight can also reside in the formation or framing of the problem itself. I think Colleen mentioned another interesting aspect to this, which is the access and equitable contributions and impact that problem formation and framing could have. So how we answer that question will shape not only inventorship disputes, but I think it will help us understand through patent law human creativity and inventiveness in this new age of AI. Thank you.
The last speaker on our panel is Jennifer Rothman from the University of Pennsylvania.
Great. I too am going to stand as the very last speaker standing on the very last panel between cocktails. And I thought maybe I would just frame my thinking and how I even thought of this question, or like, where do we go from here? Like, one could interpret that as, where should we go from here? And I at least half thought of it as, where are we going? And so most of my remarks are, where do I think we're going, which isn't necessarily where I think we should be going, and I'll try to point out the difference along the way. Second, just to frame things, I was, I think, categorized as commenting on the right of publicity, which no one has really talked about today except a few comments, which I'll also circle back to in a moment. But I want to think about it much broader than that, because part of, I think, the problem that we face in this moment of AI-generated content that is both created by ingesting the identities of people and also by the creation of content that uses other people's identities, is that people often put it in the silo of publicity rights or put it in a different silo without thinking of it more broadly. So I'm going to be talking more generally and put in context a constellation of rights emanating from a person's own identity and their attributes, their name, their likeness, voice, and other indicia, which goes beyond just publicity rights. I'm going to start with a little bit of context, what I see going on now, which is, in part, where do we go from here is very near-term future, what I see on the horizon. Second, I'll talk a little bit about sort of what I see happening in the short terms or mid-future, and finally, some predictions which are likely not to come to fruition in the long term, as well as some hopes and fears. All right, so let's start with a little bit of context. So I mentioned that sometimes people think this is just about publicity rights. That is not true. There are a whole host and constellation of rights, legal rights and entitlements that flow from the same person's same attributes. And in fact, this has created what I have elsewhere called an identity thicket. If you want to learn more about it, I have an article about it. But I want to highlight a little bit more about this and focus on, in terms of where are we and what's happening in the near future, we have an identity thicket that is growing thicker and more confusing and difficult to navigate by the day. And it is going to increasingly become untenable, and I think something will have to shift. What do I mean? What's in this identity thicket? I'm going to start with trademarks, actually. And part of this is the recent frenzy over Matthew McConaughey registering marks in himself, which I found completely mystifying. I'm like, why is there all this coverage? Why, when I'm trying to get on a train, are all these journalists calling me? People have been registering marks in their names and likenesses for decades and protecting them for more than 100 years. So I don't really understand what the whole thing is. So, but this is part of what's going on is people are looking for different strategies and ways to enforce their rights, or perhaps highlighting how rights are being separated out with potentially different controllers or owners or licensees. So trademark law, right, and here I'm going to be a little sloppy in a way that Mark McKenna will dislike, but it's somewhat efficient. But he is correct that there used to be a lot more distinction between a person using their own name as a business name or a trade name, and sometimes they put it on actual goods, and sometimes they use it as what we now consider to be service marks. I'm not going to get into the nuances of that because I don't have time, but he's correct on those distinctions. But now, writ large, the Lanham Act, state and federal unfair competition law, trademark laws protect our use of our voices, images, and names as marks, at least if we are commercializing them in some way. So all those entertainers can register marks, they can protect marks even if they're unregistered, which none of the journalists seem to understand, and can therefore protect against trademark infringement, right, service mark infringement, false endorsement, dilution, all sorts of hosts of claims under this. And this has been true for a very long time, not just for McConaughey. But the fact that he made a huge PR stunt about having those registrations is much more interesting than the fact that he did something sort of unremarkable, which is that he has a deal with 11 Labs for a use of his voice and for them being able to create a voice clone and have him speak in different languages. Many other celebrities are making these deals, so I think he may have been both trying to publicize 11 Labs, but also to sort of try to mark his territory. As I mentioned, there's a host of laws in the space. There's also false advertising laws, regulations from the FTC, and a host of consumer protection laws that also regulate these sorts of uses. Copyright law also operates in this space and maybe is less peripheral than BJ said, although I agree with the examples he gave of things being peripheral. But there are a number of really interesting open questions. One of them the Copyright Office has not yet decided. Are digital replicas of people copyrightable? Unclear. The Copyright Office has expressly said they haven't decided yet. There are pending registrations before the office. If they are registerable, could we have multiple registrations of the same person's digital replica in the way you could have multiple photographs registered of the same person's digital replica? It's not clear why not. When would a digital replica be infringed? I think we'll also see, sort of like we see McConaughey leveraging and publicizing his trademark registrations using motion marks. We will increasingly see seeing people leveraging copyright in this way. In a recent lecture called Copywriting People, I proposed that we might see more registrations and claims around copywriting one's own personality or character Bible, especially for public personalities, in the same way that we have TV show Bibles or scripts. I think we might see more leveraging of recordings and efforts to claim that they're infringed by replicating a person's identity. The music industry has already, in copyright infringement claims arising out of AI lawsuits, claimed that sound recordings were violated because the outputs used similar voices of real people. So these claims have not been determined yet in the courts, but I think will be litigated for some time and are interesting. Of course, there are right of publicity and privacy law claims, also for using a person's name, likeness, voice, and identity. This is a good moment to highlight, though I think Rob has left the room, that the right of publicity was not invented in the 1950s. In the Halen case, that is a misunderstanding of the history. And it's important to understand, not just because the history isn't right, but it's not true today, where in most states there's an overlapping set of laws, both common law publicity rights, which are largely synonymous with state privacy-based appropriation torts, but there are also some statutes, publicity statutes layered on top. Some states have both. Some states have multiple versions. Some have only a statute. And it's also important to note that the appropriation tort and the right of publicity have protected both economic and personal damages from the very beginning, and for the famous and the ordinary. So lots of rules in that space. And if that isn't enough, then we have a proliferation of state laws being passed, just 6 in California in the month of October last year, I think 6 between October and December in New York, all related to AI and largely related to individuals' identities and the use in AI, both intimate images related to student athletes, models, about labor laws that overlap with the use of digital replicas. At the federal level, we have the Take It Down Act that Rebecca Tushnet talked about earlier, which is specifically about the use in the intimate image context. We also have under consideration the No Fakes Act at the congressional level, which would regulate digital replicas, which I'll get back to in my last minute and a half here. All right, as you can see, there's so many things going on. This is the identity thicket, and it's not necessarily true that only the one underlying person is the one who controls all these rights, which potentially means that various right holders could be suing one another, which may also raise, at least for me, some very serious concerns about what we hope is a more human-centered approach like Colleen identifies. And in a recent essay and lecture called Reframing Deep Fakes, I talked a little bit about how we should be thinking about some of these issues, some of my concerns about no fakes, and about a disconnect between the way the U.S. is dealing with some of these problems, which is largely leading into a copyright-based model and purely economic-based model, versus the way the EU is handling some of these things, which focuses on concerns about the underlying person being depicted in AI-generated works, as well as concerns over the deception of the public. All right, in my 30 seconds, I'm going to give you the short and long-term version. In the short term, I think we might see federal legislation, but we also might not. And depending who I ask, I can talk to someone on Capitol Hill in one office and they'll say it's definitely happening, and I'll talk to someone else the same day, they're like, it's definitely not happening. But this will not help matters very much because it is unlikely to preempt this thicket of all the other things. I'm gonna grab one more minute. But also, it will not address our concerns. The No Fakes Act is the one that has the most legs about being able to transfer rights away from the underlying person, and it also will not address concerns over deception because that's not what the people involved in the legislation want to do. Second thing in the short-term horizon is maybe efforts at more state harmonization, and I'm working on a project for the Uniform Law Commission that's considering proposing a model state right of publicity law, which would try to harmonize some of the discontinuity across laws. Maybe we'll see more concern about my big worry over many, many years that people finally are seeing is actually a problem, which is transferring someone's own name, likeness, and voice away from them, potentially forever. And I've actually seen the Screen Actors Guild back away from seeking transferability, as well as members of the Senate and House who removed transferability from the No Fakes Act. We might see more of an appetite, which will cause a stir in this room, about repealing or limiting the Communications Decency Act, Section 230. I think we also will see some shifts ongoing in technology that can help detect and build guardrails around the use of a person's identity. And we might see some market shifts in people's preferences, which was noted already on this panel about people craving authenticity. I have a hope for the renaissance of live theater, but it may not come to be. I'm definitely out of time now, so I'll just say in the long term, it's really hard to say what direction we're going, but whatever direction we go, I hope that when it comes to identity rights, we remain focused, and particularly in the context of AI, on the person depicted and captured, not on their mere monetization and potential ownership by others, and also keep central the potential deception of the public. I will cease.
Great. Let's turn to our panel since our time is short. Let me begin with a question about timing, since we're trying to project into the future. The law has always lagged behind disruptive new technologies. Yet, related to that first, we have a lack of clarity on basically everything. It seems like, we talk about inventorship, authorship, is training fair use, deepfakes. There are a whole host of really fundamental questions that the law is unclear. And there are scenarios in which, if this eventually goes to the Supreme Court on any of those issues, let's say 10 years later, or it seems like it could dramatically alter the course of AI innovation or development. Pam has already referred to the doomsday scenario of destruction of models. Could you imagine destruction of models? But it doesn't even have to be that dire. It could be what Keith's presentation about inventorship. It turns out when the courts get it, basically nobody can get a patent because they've used AI. It's not assisted in the court's view or whatever. So my question to the panel is that this lack of clarity and yet the great adoption of AI that we're seeing, will it run into a collision where some of the court decisions, or if Congress steps in, sort of are counterproductive or dramatically alter the AI innovation?
Well, I just want to actually pick up on what Jennifer ended with in terms of contrasting the U.S. and European systems in terms of what are the underlying interests in intellectual property. And we, my sort of international IP class, I teach sort of the difference between utilitarian approaches and natural rights approaches, and how there, I think, in that dichotomy, we still have a market-based system where IP is, one factor, but we obviously have a lot going on with private ordering. And I don't see that the courts are going to really upend where the market is moving forward. So whether it is sort of the slow pace at which we're getting to the Supreme Court on copyright fair use, in the meantime, the market is not staying still. All these licenses are being entered into. You're seeing Europe move forward with its regime. And so I feel like in a lot of ways, it's good to think about what might be upended by the courts, and in certain situations that will take place. But in a lot of times, I think it's going to be about the technology doing what the market is requiring and demanding for its evolution. And I feel like IP will recede in some ways in importance.
And the time it takes could potentially be generative in a different sense. If we're taking time and if these processes are sort of deliberate and thoughtful, then maybe we're working through some of the questions along the way. Like sometimes we're talking about, how do we apply the law to this new thing? And some of those, we might get relatively straightforward answers. Okay, there's a line to be drawn between AI created or AI assisted, and if you cross that line, you don't get authorship, you don't get inventorship. But then you get some further questions, like, okay, well, what is the system trying to do, and how do we need to define this to deal with those things? If it has become so easy, with going back to the Dan Burke quote, if it's become so easy to create the things that previously took substantial investment and large amounts of time, then what is the role of copyright or patent in those things? And those are things that I don't think it's easy to work out the answer, except through a more deliberative process. That being said, I'm not sure that that's really what we're getting in the absence of some sort of more focused study on these things.
I think that I'm reminded of Pam Samuelson's comments from earlier about legislation in the copyright space around technological change. And one of the advantages of courts rather than legislatures dealing with technological change is that technology changes very rapidly. And so by the time Congress passes something, it can often be obsolete or wrong or obstructionist. And I think I would much prefer at this point to let some of the litigation in the AI space work itself out in copyright related to use of people's identities, trademark claims, privacy and publicity claims. And so far, I'm seeing courts, at least from my perspective, grappling with it in what seems like the right ways, and we're seeing a little bit of different outcomes. But I think we might get somewhere that would set up some useful and workable guidelines. And as the technology develops, as licensing deals are made, as guardrails get better, as detection software gets better, as people are starting to make choices about certified human uses or disclosure of AI uses and what the norms will be around that, rushing into the breach is probably not the best solution. And I do have some significant concerns about, which I flagged at the beginning, about the identity thicket, as states rush in with very little deliberation and process and now have a host of conflicting laws that regulate AI, how the companies are going to be able to negotiate this. I'm also very concerned about the No Fakes Act going forward in its current version because it doesn't protect the underlying person from losing control over their name, likeness, and voice. And there's a big difference, I think, between states sort of haphazardly suggesting that someone's rights could be transferable and leaving a lot of latitude for courts to come in and say, actually, that would be unconstitutional. Whereas I think if Congress claims that that's completely legitimate, it will be a tougher road in litigation to claim that it's unconstitutional. And the payoff for the federal law in terms of regulating AI, I'm not sure that if that passed it would be so bad for AI, but I think it would be very bad for the public and individual people. As currently drafted, the motion picture industry gets exactly what it wants, and Google, YouTube gets exactly what it wants, and not many other folks.
I don't know, Keith, if you have any comment on. No. Okay, great. No.
So is it largely a question about AI? Going back to the question, it was about AI, right?
Yes.
Okay, good. So that's good. So I'll say, following up on BJ's response, I think some of, at least in trade secret law, I would say a lot of this is simply applying the doctrine such as it is to this new technology. And so a couple of issues have arisen already, and I think we are sort of starting to have responses. So does disclosing a trade secret to an artificial intelligence model like ChatGPT destroy trade secrecy through failure to take reasonable secrecy precautions? There was a pro se case actually holding just that, Trinidad versus OpenAI. It's a fun case, but basically if you share your secrets with AI, you can lose them. Which seems obviously correct to me. Does artificial intelligence render some existing trade secrets readily ascertainable and not protectable? So, for example, formula for Coca-Cola, if now a really smart AI that anyone can use can figure this out, does the Coca-Cola formula no longer qualify? I say yes in theory, but due to what I was saying before about how courts are very hesitant to apply the readily ascertainable doctrine, they possibly know in practice. But there are a lot of things we're getting answers on. Can purely AI-generated information, like a new invention that an AI comes up with, can that be protected as a trade secret, that's actually pretty straightforward. Yes, there's no even creator requirement. It's a standing and ownership issue. So I think I'm kind of, at least with regard to trade secrecy, I'm in BJ's camp that we definitely don't need new laws per se for this particular issue.
Okay, there's a second question is there's a lot of expectation of the proliferation of AI agents, and maybe some of you are using AI agents already, as well as robots. And this sort of intersects with, Camilla, your comment. If we assume AI agents and robots will be sort of autonomously doing things that involve what we would, in the traditional sense, have protected under IP laws, if it were human-centered or human-based, will that sort of proliferation of AI agents and robots cause disruption to our existing IP systems, even potentially making them irrelevant or obsolete, to the extent that the production of sort of IP becomes much more through autonomous agents?
Can I chime in really quick, Ed?
Yeah.
Yeah. So, first, what a great time to be a scholar in IP law, right? So I think what I find interesting is the proliferation through these AI agents and other AI tools of quote unquote unprotected IP that is being generated, and the question then becomes, are we going to start having to label things as human generated? I think I've started to see some podcasts already being labeled as such, and what value the IP system will place on human generated versus non human generated IP. I have started to play around with an AI agent. I think they changed it. It was Claudebot, now it's something else. Haven't been able to do anything too interesting with that yet, but I do think it is a fascinating development where these AI agents will be considered, from an agency law perspective, someone's agent, and what are the legal implications of that.
Yeah, I mean, I think if everybody performs a thought experiment, the 50-year anniversary after this conference, will we be looking back and saying, okay, well, now the world has dramatically changed in terms of knowledge-based production. And it seems like the trajectory we're headed, there's one scenario where that seems like it is potentially very likely to occur. I do want to make sure I leave a little bit of time for any questions from the audience. So, yes.
Hi, thanks for a great panel. I have, what I find interesting and kind of to sum up everything, when you go back to the 1976 Copyright Act, the Patent Law Act, the UTSA, the IP bar was very involved in the conversations leading to those acts, and they wanted balance and they wanted to solve problems in a realistic way. And they're not involved at all. Like, I just went on no offense to the people that are members of the AIPLA here, but the AIPLA website, if you look at their legislative activity, the main thing is to amend Section 101, which of course hasn't been discussed here today. And so there's an obvious disconnect for some reason between us, the academics, and the bar. And so maybe one of the things we need to think about is how do we improve that so that we can get back to actually discussing, what should be the policies governing IP.
Does anybody have a response?
I don't, this is partially non-responsive, but it occurred to me when you said, what you said about the 1976 Copyright Act, is that Section 301 of the Copyright Act, the preemption provision, has some fascinating legislative history about whether it preempts privacy and publicity rights or doesn't. And there was language that was included and then deleted, and if you do an even deeper dive in the legislative history, there's a disagreement about why it was deleted, right? Like one camp saying it was unnecessary because it was obvious, and one camp saying it's not supposed to be preempted, and so that's why we took it. Like, it just, so there were lots of unanswered questions at that time that we still are living with today, occurs to me as a response. In terms of working with the, sort of the broader community, I do think that this, at least in this particular area that I flagged, the Uniform Law Commission is trying to do something at least at the state level, and we actually have members of congressional staff at the Senate and House level who are also participating. But I don't know if it'll succeed.
And just another comment. What I've observed also is that the companies with the deepest financial interests are just focusing in other venues or on other battles right now. So, ALI has stood up an AI project, but it's really focused on liability. There's a lot of focus on 230 and First Amendment and all these sort of cases that Netflix is on the other side of the V for. So I think those are higher priority in terms of things that might be threats to the actual business model, and IG is going after companies for this for actual harm that's taking place. So I think this may be lower on the priority scale for the companies that are actually making the technology.
Thank you. My question is kind of inspired by Professor Ed Lee's question of imagine 50 years from now what we would be dealing with. So I was wondering if Professor Robinson could answer this question. You mentioned in granting patent, we should be, maybe it would be fruitful to shift from problem solution to problem formation as a paradigm of assessing who we should award inventorship or the benefit of inventorship to. So my question is, how do we prevent a future where companies with all the computing power and all the data, like Google and Disney, from monopolizing all future inventorship and authorship? How do we prevent a future where we are just consumers and not possible to become inventors and authors anymore? Thank you.
Yeah, so that's a great question. My answer is going to be a little bit negative. I think we're already in that situation which you state. If you look at the data about content consuming versus creating, I think we have far more consumers of content than we do the folks that create it. And if you look at the companies that control the data, control these AI models, it is the top 2-3%. So I think that we start first with that realization that that's where we are. I think that we have to start at a grassroots level, encouraging more creation, encouraging more of our kids and students to create instead of just becoming consumers of content. But I think we don't have to wait 50 years for the situation you describe. I think we're in that situation currently, unfortunately.
With that, I think we have run out of time, so please join me in thanking our panel for their excellent.
Sorry to end on a downer.
And I think we have concluded the conference, unless, Brian, you have anything else to... No? We have a reception outside, so please stay and enjoy the reception. Thank you all for sticking it through to the end, and we'll do this sooner than 50 years from now.